Lola and I'm a UK qualified employment law solicitor. Welcome to my channel. Today I'm going to be going through something that's very important, very popular in employment law. Before I reveal it, let's do a drum roll. The topic today is settlement agreements. Now I'm going to go through the top 10 tips that I've devised of things that you need to look out for when you're presented with a settlement agreement as an employee and you need to review and sign. So think of these top 10 tips before you sign on that dotted line. Let's get straight into the tips. Tip number 1. I'm stating the obvious here, but you need to know what the settlement agreement is. A settlement agreement is a legally binding contract between an employer and an employee, and this contract is entered into to end the employment relationship. And as part of ending the employment relationship, the employee is agreeing not to pursue any claims against the employer, and the employer is agreeing to pay to the employee a fixed sum, a termination payment. So it's essentially a clean break. The employer walks away knowing that there aren't going to be any claims pursued against them, and the employee walks away with a fixed termination payment, a fixed sum of money. Moving on to tip number 2. Now, what's most important to the employee? Let's all be honest here, it's the money. So when it comes to the money, there'll be a specific section in the settlement agreement which sets out the termination payment. The specific sum that's going to be paid to the employee as part of the termination payment should be specified. And in terms of the termination payment, you need to understand that £30,000 of that termination payment is tax-free. So if your termination payment is below £30,000, you don't need to worry about tax coming into play. Every single penny is tax-free. However, if the termination payment is above £30,000, then you need to understand that at least whatever the remaining amount is above that £30,000 will be subject to tax. That tax is income tax and national insurance deductions. So a simple example is if your termination payment is £50,000, £30,000 of that payment is tax-free, the remaining £20,000 will be subject to tax, will be subject to those national insurance deductions and the income tax. Okay, aside from the termination payment itself, any payments for accrued or untaken holiday should be specified in the settlement agreement, and holiday pay payments are subject to tax. That's again the income tax and the national insurance deductions. And also, if any payment in lieu of notice is applicable and will be paid by the employer, that needs to be set out in the settlement agreement. And this is separate to the termination payment. So let's say that your contractual notice period is 3 months, but you haven't worked the entire 3 months, you're being paid in lieu of notice instead, then the payment that will be paid in lieu of notice needs to be specified, the full sum, and that will be your before tax sum because it is, you guessed it, subject to national insurance deductions and income tax. So moving on to number 3, that's the payments done. What's most critical to the employee is the money. What's most critical to the employer is the claims that you are waiving as an employee. So typically there'll be a very, very long list of claims which can span over about 4 or 5 pages or more. And the claims that you will be waiving will include things such as unfair dismissal, discrimination. What can't be waived, there are certain claims that can't be waived. What can't be waived is any claims in relation to pension and any claims in relation to personal injury. So the list of claims, you as the employee, just make sure that you read through those, you understand the implications here, you are waiving your right to pursue any of these claims at a future date. Moving on to tip number 4, and that is in relation to the termination arrangements. Of course, as the employee, you want to know what your termination date is, and you also want to understand what you need to do up to the termination date. Will you be actually working the entire notice? So as I mentioned earlier, you might be paid in lieu of notice as opposed to you working your notice. If you're going to be paid in lieu of notice, the agreement is to specify that. Are you going to be required to perform a handover? If you are, the agreement should reference this. And are you going to be placed on garden leave, or you'll be working throughout as normal? The agreement needs to specify this. So the termination arrangements should be clearly set out in the agreement. Moving on to tip number 5, and that is in relation to the warranties. Now, these are warranties that you as the employee are confirming are true, are correct. And these will include things such as you agreeing that you haven't breached any of your employment contract provisions, or you haven't committed any gross misconduct as an employee, and the employer is offering this termination payment, offering the settlement agreement on the basis that those warranties are correct, are true. So if there are any issues with those warranties, just flag those up, because you need to be very careful here. The warranties, if they transpire at a later date to be incorrect, then the employer can withhold the termination payment from the employee. Moving on to tip number 6, and that is in relation to returning of company property. So the laptop, the phone, any property that was given to you by your employer at the beginning of the employment relationship, or just at any stage in the employment relationship, will need to be returned, and there will be provisions in the settlement agreements which specify exactly when you need to do that, by the timing. So it may be before the termination date, by the termination date, on the termination date, after the termination date, 2 days after, a week after, whatever it may be in terms of the timing. Just make sure that you read through, you understand what you need to do, and that you comply with the relevant provision. And also, aside from returning company property, there's usually reference to you having to delete any information, any data, anything related to the employer that may now be on personal devices of yours. So do make sure that you comply with that, because again, if there are any breaches, the employer can withhold the termination payment. Moving on to tip number 7, and that's in relation to confidentiality. The confidentiality provisions, similarly to the return of company property ones, are crucial in terms of you making sure you comply, because if you don't comply, there is a risk that termination payment can be withheld. So the confidentiality provisions will clearly let you know who you can disclose the agreement to, and that's usually a small number of people, so immediate family members, your partner, your spouse, and your legal advisor, of course, and anybody outside of the specific people who have been referenced, you should not be disclosing the agreement to. So be careful here. That does include employees. I've had cases where employees have been discussing the terms of their settlement with other employees, but that's not allowed in the settlement agreement. So just be very careful. Make sure you understand what you need to do and you comply. Any breaches can result in the termination payment being withheld from you. Moving on to tip number 8, and that is in relation to references. So of course you want to ensure that when you move on to your next role, when your future employer needs a reference, that there aren't going to be any issues. So the settlement agreement, I've only had one which didn't actually have this off the bat. The settlement agreement will typically include references in a schedule, and if the reference wasn't included, that case that I mentioned, when it wasn't included, just flag this up and included wording to make sure that the reference was included. Make sure that the settlement agreement has that wording in the reference of a reference to say what the agreed form is, and very importantly, make sure that it's not just the written reference that's agreed. Make sure the settlement agreement refers to the fact that any oral, any verbal references, so let's say your future employer picks up the phone to the previous employer, anything that's given verbally, orally will be consistent with a written reference which is included in the settlement agreement in the schedule. Moving on to tip 9, penultimate tip. So tip 9 is in relation to the legal advice certificate. So your legal advisor will have a certain section, it's usually a schedule, that will be where they need to sign, and that will be usually on their firm letterhead, and they need to, your legal advisor, include their name, the law firm that they practice at, the law firm's address, and also include their signature. Now, until this is all completed and finalised, you won't receive a termination payment. All the parties, the employer, the employee, you, the legal advisor, all need to sign, all need to finalise their sections. So just make sure that you are aware of that before you enter into the settlement agreement. And last but not least, tip number 10, that is in relation to the entire agreement clause. Now, that pretty much says what it does on the tin, does what it says on the tin. And that sums up everything. It's usually towards the back of the agreement, just before the references, the schedule for the legal advisor certificates. It's usually around the very end of the agreement. The entire agreement clause essentially is confirming that everything which has been agreed between the parties is in the settlement agreement. Anything outside of the settlement agreement has been essentially superseded, doesn't exist, doesn't matter, doesn't need to be honoured by any of the parties because it's not in the settlement agreement. So be very careful here. I had a case where an employee was expecting a bonus payment that had been agreed in a separate email, but that wasn't in the settlement agreement. There were no references to that bonus in the settlement agreement. So unless a reference is included to that bonus, the employer does not need to pay out that bonus because they only need to honour what's in the settlement agreement. So just be very careful there. Make sure that anything that's been agreed with your employer, so whether that's a conversation in person or email correspondence, make sure anything that's been agreed is included in that settlement agreement, because the entire agreement clause restricts what needs to be complied with to just what's in the settlement agreement. All right, so that was my final tip, and thank you so much for watching with me until this point, if you're still here. And I'm really looking forward to the next one. Please do like, comment, share and subscribe. And if you have any suggestions for topics, do share with me. I would love to hear your suggestions, your recommendations, and I really look forward to seeing you in the next one. Thank you.